The search and seizure of the warrant was illegal because the warrant is insufficient on its face. There wasn't probable cause for the issuance of the warrant, or the warrant was illegally executed. The motion shall be in writing, which that one was. State facts showing the search and seizure were unlawful, which it was. The judge shall receive evidence outside the presence of the jury on any issue of fact necessary to determine the motion, and the burden of proof.
State's reliance on Alford, State versus Alford, the state's reliance on this narrow window that only the Honorable Judge Newkirk suppressed marijuana is frivolous. On page 43, starting line 4, I continued. But then when the court goes through and looks at the search warrant itself, the only way we would have probable cause in the search warrant is if the court finds that law enforcement officers on the day that this happened actually had the lawful right to go in the house and to observe, because everything else in that search warrant does not produce probable cause to search Mr. Williams' home. Then it continues on page 45. On line 4, at the end, I say in the middle of the sentence, nothing is attached showing that this arrest warrant was valid from DeKalb County. On line 40, page 46, on line 5, the next issue, Your Honor, that is asserted is that law enforcement officers entered Mr. Williams' home on the day that we're talking about. And I challenge that in the supplemental motion with the fact that it was read to this honorable court by the district attorney, supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home because I'm challenging the arrest warrant was not valid if there is an arrest warrant. And the last issue in the affidavit for the search warrant discusses items that were located by law enforcement officers during the search on the day that you heard about, which I would say is a fruit of the poisonous tree. So I have 3 issues. 1, there is no at all arrest warrant presented to this court. So under Baez, which I have a copy for the court, how can I challenge the arrest warrant? How can the court say it's a lawful arrest of Mr. Williams at his home without being armed with a certified copy of the arrest warrant? Therefore, and I stress this, Your Honor, every of the poisonous tree. On page 47 of the transcript in courts number 2, on line 9, I continued. So the only thing we're left with is the unlawful entries into Mr. Williams' home, and I would ask the court, based upon that, suppress the evidence, grant the motion to suppress. Mr. Bailey then speaks on page 47, line 14, and going to line 18. At the last word, he says, this motion to suppress the search of a home that the defense is alleging is illegal. Nobody's talking about only marijuana. Mr. Bailey continues on page 48, in line 10 in the middle. The only 2 questions you're...
Yo, y'all can't hear it? If y'all can't hear it, tell me. I'll turn it up. But I think what's happening is that they're broadcasting in mono, so it's coming through 1 channel. It's not coming through 2. What y'all want? You only hear 1 ear, right? Yeah, that's their audio. It's fucked up, but I can turn it up though.
Anything like that. The court then, page 49, on line 6, says to the state, in which case you would have produced a copy of the arrest warrant. And Mr. Bailey says, right, which would have been a subject, I'm sure, of the suppression motion at that point. And then the Honorable Judge Newkirk said, well, it sounds like Mr. Steele made the arrest warrant a subject of this motion, also in a supplemental motion, which the court file does not have. What
Why is this muted?
The prosecutor says, And that is the copy, the supplemental one. Again, he's not challenging the arrest in this case. He mentioned something in there about the DeKalb arrest warrant. If he wants, there's no need to challenge the DeKalb arrest warrant now because the case was dismissed. But there is a forum for doing that, and that may be what they did in the case. Maybe they challenged the arrest warrant in that case. On page 51 of court's number 2, the district attorney states on line 6, that doesn't mean that because there's not a certified copy of that arrest warrant, that has any bearing at all on whether the entry and subsequent search of this house was proper. Everyone's talking, Your Honor, about the entry. That would be the state's argument in the case. At line 11, the Honorable Judge Newkirk said, all right, tell me again about Baez. I'm not familiar with it. What is the site? Is it Supreme Court or Georgia Supreme Court? I say Court of Appeals. I give the court the site. And then on line 51.
51, okay.
Yes, sir.
Yep.
And then on line, the court asked me for a summation on Baez again, and I said, okay, that's on line 22. So it's a motion to suppress like we're dealing with here. Law enforcement officers have obtained a search warrant after an arrest warrant. So it's the same sequence here. Going on to page 52, Your Honor. Law enforcement officers utilize the arrest warrant. They call it several things, bench warrant, arrest warrant. And just like Mr. Williams, it was challenged whether it was a valid arrest warrant. The motion to suppress hearing goes forward. The prosecution doesn't put forth the arrest warrant. The Court of Appeals says without the arrest warrant, it is not in the record. We are not finding there was an arrest warrant. It was challenged, and they suppress the evidence and find it is a fruit of, since there's no basis in the record to have an arrest warrant, everything thereafter is unlawful. That's exactly what I think happened here. That's why I used the case. Why did I make the supplemental motion to suppress all evidence located from Mr. Williams' home? Your Honor, I was challenging everything. It is clear. And I'll get to the Judge Newkirk's order because it's not a fair reading of the order to say only the marijuana. That's not true. I didn't write that order, by the way. On page 52, line 23, I say, and I don't want to play games with anybody. I put it in its own paragraph. I made it a supplemental because I realized there was a problem with the arrest warrant. So I made paragraph 7 standing alone or standing on its own. And I wrote, moreover, law enforcement officers were not armed with a valid arrest warrant in DeKalb County at the time of entering Mr. Williams' home. And thus, and Your Honor, I'm stressing this, all evidence must be suppressed on page 53, lines 1 through 5. Then skipping to line 15, I again.
Yo, salute Drunken Driver for I think like 5 gifted. Thank you, brother. Jinx 9110, thank you for 5 gifted as well. Thank all y'all for showing up today, man. We're hopping into it. I'm not even doing intros this week. You feel me? Usually I get right. We're getting straight into shit. But everybody, thank you for the subs. And YouTube should be online. If you guys have problems with the audio, I'll try to fix it. But the audio is a little fucked up through the court. It should be sounding fine when I talk. But I'm gonna keep going.
We challenge that there's no valid arrest warrant, and then it's not saved later, in my opinion, the search, because I don't know how else law enforcement gets in the home. Because now, you know, thank God there's not a shootout in the house where law enforcement had to go there. On page 54, line 5, Your Honor, I continue. So I don't know how law enforcement, without a valid arrest warrant here today, has any evidence to go before the court. And that is why I made an issue of the other items in the search warrant, like the confidential source, the alleged confidential.
Hi, FPS. Thank you for the 5 gifted, brother. I think it's brother. I got to start thinking that it could be Chat Queens up in here, but thank you for the 5 gifted.
The court states, the Honorable Judge Newkirk, on page 55, its ruling. On line 18, the court says as follows. All right, Mr. Steele, I'm going to go with you on this. I think you are correct. I think the burden is on the state to show the initial arrest warrant was valid and initial entry into the house was valid. And he hasn't done that, meaning the prosecutor has not done that. It appears there's no testimony from any officer. Certainly, there's no need for her to go back in the house without a search warrant. It doesn't sound like she searched for anything, so that might have been harmless, excuse me. That might have been harmless error because the arresting officers discovered it and went out and told them. And this is what I'm stressing. Line 4, page 56, the Honorable Court's ruling. But I don't think we get to that hurdle because the lack of authority shown to the court that they had permission, meaning the police had permission to enter the house on the front side. So I will grant your motion, Mr. Steele, if you will prepare a proposed order. I never did the proposed order. I don't know why I wouldn't do that when I'm told. Maybe I did and the judge didn't like it. That's not my order. The bottom line I'm trying to tell this honorable court with as much earnest and power and professionalism as I can is I do not want to relitigate this after I gave a roadmap to the prosecution on how to litigate. If they need me to help them litigate a case, I'm not helping them. The issue here is we had the hearing. I challenged the initial entry into Mr. Williams' home.
Yo, this nigga is tight. Gunner is all smiles, putting back the diamonds in his teeth. He doing whippets out the ass right now, getting his dick sucked by that bad bitch with the new fresh BBL, and Thug's lawyer in court mad as a motherfucker. You hear this nigga, man? This thing is tight. By the way, thank you for telling me that Thug video is old. Yo, I put it on the shelf that I could review to make sure it's new, but god damn it. I kid you not, I thought Thug was going to show up in court and possibly take a plea too. I thought because he's been doing these conference calls where like he's at the jail and they're just like FaceTiming him in every single time. Today's the first time I've seen him show up in suit in court. Usually they wait for that around trial time, but he showed up in suit and he's smiling like a motherfucker. So I thought he was going to walk out. But the way this nigga's arguing, look like they just acknowledge that they're in deeper shit. Thug is smiling, but his lawyer's tight.
I forget the number.
It is D4.
And Your Honor,
That's the first one.
thank you, sir. And it's entitled, it's filed, I know the hearing was on the 3rd of April, 2017.
Filed in on the 11th of April,
Right.
2017.
So D4, order granting supplemental motion to suppress.
For those who are just tuning in, let me tell you what's going on. So they're trying to suppress evidence. There's a few things that Thug is fighting. Number one, Gunner just came out and said, yo, remember when that traffic stop happened that you said you caught some drugs and some gun in the car? That shit definitely ain't mine. And I'll testify that it ain't mine, which almost says if it ain't mine and it's only two of us in the car, you know what I mean? One of those type of shit. So they're trying to fight that evidence a little bit, but what they're really also definitely trying to fight is the evidence that they found all these weapons and silencers and shit like that in Young Thug's crib. He's saying that, listen, they didn't have really a search warrant to go look for those things. They only had a warrant to take him into custody, and they went beyond the scope of that warrant. That's why they found those things, which means those things should be thrown out. To keep it real, if I'm going with this judge, I think this judge going to say, fuck out of here. But this nigga, he's arguing. He's trying. He's trying, bro. You got to imagine Thug looked at him and said, yo, Gunner just got out of here on a vacation. Like, bro, what's going on?
The judge got that language. I know I didn't do this order because I would always say the honorable court. This is just not the way I'd write an order. But you know where the court did get the language of what the state was relying, specifically just over announced marijuana? It's in my motion. I said suppress everything, specifically including the marijuana. It is not true what they are telling this honorable court, and that's not acceptable. Then you go to the search warrant. The state wants to rely on a search warrant from 2016. It was signed by the Honorable Judge Woodson. It is signed and it's in your court's file. I believe it's defendant's number 10. I'm going to tell this honorable court. And it was signed on June 27, 2016.
I have the warrant for search and seizure as D10. You introduced that last time.
So, Your Honor, this is the same items that were taken from Mr. Williams' home in July of 2015. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant. And Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court, like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2017. The state then sends Mr. Williams devices when they won't give it back to him. They won't restore it to Mr. Williams or his father, who had a power of attorney. They go to Cellbrite, and Cellbrite now has better.
I don't know if they're intentionally doing this or it's just like falling out. I don't know if they're intentionally doing this or it's falling out. I'll tell you this though. Why sell the label? Their label Instagram did welcome Gunna back home. So I think people are looking and waiting for the official word on is, and by the way, when the audio comes back in, I'll go back over there. People are looking at the official, what's the official word on Gunna from like thugging them. And shit. This is yesterday though, but the label's Twitter posted first day out with the slime emoji, tagged Gunna, and we see Gunna right here.
The items. They don't get another search warrant. The legislature then says at the last 3 lines of this code section, Your Honor, any search warrant not executed within 10 days from the time of issuance shall be void.
Oh, Mrs. Gill, sorry.
Okay. By the way, to also summarize, they're talking about a cell phone. So Young Thug's cell phone got seized in 2015. Basically, they try to get into it, right? But they had a search warrant. So they try to get into it. The company that usually could get into cell phones, whether locked or not, they get deleted and everything. The company says they couldn't get into Young Thug's phone for whatever reason, okay? Their technology was not that advanced yet. Maybe it was a new cell phone, right? Anyway, they later on they come back to say we can get in the cell phone now, but it's like a year later, and cops say, well, send us what's in there. He's arguing the warrant said y'all could have only checked the phone within that finite time, 10 days. Y'all niggas checked it a year later. Anything you got from that cell phone, including Young Thug talking about, yo, niggas got to get sacrificed for the cause. Thug was talking extra spicy. And basically, he wants all that evidence thrown out. That would be big and a huge win if Thug gets it thrown out, because already, and by the way, I think this is why the state is cutting deals with other people, because if this evidence gets thrown out, the only way you send Young Thug up the river for 30 years is you need the people who was sitting with them, pictured with them, kicking it with them to say, nah, you big slime. You the nigga who ordered all this shit. I seen you did this. And once they start doing that, there will be no more Young Thug. Let's keep it 100.
Here. And they want to do it again. I respectfully ask the court to enforce the collateral estoppel, res judicata, law of the case. It should have been restored. The police should not have had that evidence. It should have been given back to Mr. Williams. He shouldn't even have to ask for it. And I think that State versus Alford, I'm sure the court has read it. It is telling the court something that the case does not discuss. It is just not even arguable that case matters to this. They had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you ask me. I hope I answered your question. And I think I'll answer any other question, but I hope I answered your question.
You did, sir. You did. Ms. Rosenwald?
Apparently, most of the defendants are in court.
I know Mr. Steele has an interpretation of the language of the order.
This is a prosecutor. The last prosecutor left to Gwinnett County.
Yeah, I mean, I look at the way it's capped, it's styled and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time, and it's clear in the transcript that he did in fact assert the fruit of the poisonous tree. I mean,
So, Your Honor, if I may, when I looked at this case first and I saw his motion,
Oh, the judge looked like finally he's kind of weighing in Thug's side.
the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking.
By the way, I'm giving some context because y'all might be lost. So what fully happened? Remember I told you about the cell phone thing? The Young Thug's lawyer had went to the court after basically they had his phone for a while. They didn't do anything. They said, okay, y'all got no charges on him? They said, we got no charges on him. You can have your shit back, right? Cool. When they basically were supposed to give it back, they asked for the judge to suppress all that evidence that it could not be used later. The judge agreed. Now that's why they're saying later y'all trying to use evidence like a cell phone that was eventually suppressed because y'all couldn't get it back then, but y'all could get it back now. Y'all could get it now. Nah, no go. Let me see what the judge is saying. Sorry.
it's true, or the minimum should have been returned to Mr. Williams.
And so, Your Honor, I do want to pivot that if this court right now today says, hey, I'm wrong, and Your Honor finds that the cell phones are fruit of a poisonous tree, now and only now would Mr. Williams be able to demand his cell phones back. There has never been a ruling on the cell phones until this day, and I think that's really clear from the court's language in the transcript.
I don't know why this is happening.
In the transcript, the court says, and this is in the court's ruling, and Mr. Steele actually read it, it says we didn't get to that hurdle. So this is at page 55 to 56.
Okay. We might take a break from this just because it looks like some things are happening. Anyway, we're piggybacking all over the place. We got Megan Tory shit going on. Apparently, right now, Kelsey's on the stand yet again. She is on the stand. Okay. Let me see. Wait, I'm trying to see if I can see. This was Tory's arrival this morning. I want to know who this young woman is. I don't know if she's an assistant or maybe somebody on Tory's team or maybe some type of attorney, but she seems to oftentimes engage with Tory's attorney like during breaks. Okay. Somebody said that's his mom. I don't think so. I said go back. The audio might be so fucked about trying.
But there's been no time to litigate that. The question.
Let me just refresh it. Maybe it's me.
Previous ruling on the.
No, it's not me. It's the thing. All right, so that's happening right now. Let me see who else has been covering this shit. There's been a few other people kind of covering this. James Quilly. Let me see what he says. There are now raffle tickets for the public to get in to the Tory Lanez trial. what is life anymore? Yes, there's an enormous amount of people that want to go there, and clearly they have limited space. So I see what's going on. And somebody said Tori mom actually passed away. You remember Meg kept saying she got close to Tori because her mom passed away. Tori's mom passed away. Anyway, I do want to really quickly, as we're jumping all over the place until we get some real news out of court. We've been covering the Meg and Kelsey case for a bit. Anyway, Young Thug is in court today for a suppression hearing, maybe among other things. I kind of thought it might have been a plea agreement that he may have reached to, which I would have said this whole case is just garbage, because if y'all let go one of the co-founders, which was Walter Murphy, which obviously he's not famous, right? So nobody's caring what plea deal he signed. I got to imagine his plea deal also says he might have to testify too. I'm just saying, right? They're letting some niggas out of jail extra early, and some niggas they're trying to pile on. So you got to realize they're setting sights on few people. Jeffrey Williams, aka Young Thug, is definitely one of them. They're definitely setting sights on. Anyway, the conversation that people are talking about, did Gunna snitch or not? I've been noticing everybody's hesitant to talk about it. And I think people are going to really allow Young Thug to basically come out and either say that dude is snitching on me or say he's not. And honestly, if Thug comes out and Thug doesn't say that Gunna snitched on him, I don't think people will call Gunna a snitch, honestly. You get what I mean? I think everybody's been guarded in their words. I seen Meek Mill yesterday tweet out, yo, welcome back, Gunna. You ain't deserve to be there. But then he deleted the tweet. And I think everybody's kind of in limbo, not trying to jump out the window because, again, at the end of the day, none of these guys in the industry are friends. All of these guys are really just pretending. And in reality, nobody wants to diss somebody or say something or that you can't take back. So I think they're waiting on the official word. Somebody says Milagros tweeted an update. All right, we'll be over there. Come on. Let's see what's going on. She said, what now? She said she was in Twitter jail for a while. It says, she says, okay, so this is Kelsey. Kelsey says the prosecution pressured her to come in and speak in September, and she felt like she had to. She says she hasn't spoken to Tory since she retrieved her items from him on July 13, 2020. She says Tory nor anyone from his team has harassed or tried to contact or speak to her in any capacity. Holy. Essentially, the prosecutor is now trying to spin this angle of saying, yo, Kelsey, tell us how much you got paid, baby. How much you got paid by Tory now? You over here fucking up our case. We can't send Tory to jail with you talking like this. But at least just tell us that nigga is threatening you. Tell us. She's saying, nah, I haven't talked to that dude. Holy. Kelsey is going crazy still. I did think that maybe after a long night of sleep, and she probably seen certain things online where people are saying, yo, you not going to back your friend up, all that type of stuff. Maybe should have either changed her tune or broke down or be like, yo, listen, whatever. Or I don't know, like been a little bit more aggressive in trying to expose Tory. She still seemed like she got no plans to try to say anything meaningful and qualitative that could sink Tory Lanez, which is a big W for Tory. So we're going to keep monitoring that. If she goes live or sends out more tweets, let me know. Okay. Obviously, the thing that people are worried about is did wanna bite the cheese. Okay. Did wanna bite the cheese. Now, of course, 6ix9ine couldn't wait to like kind of talk about it. But even the only rapper who talked about it directly was Boosie. And Boosie straight up said, this nigga's ratting. If you haven't seen the clip of Gunna in court, you know what I mean? As I said, me personally, I would never call Wanna a snitch. I just think he's a truth teller. He told the truth. He ain't tell, okay? And obviously, I'm not in the street, so it don't matter either way. So don't take my word for it. You do your own thing. Hold on. What's that? Shaggy Ali said, heard your girl Milagro was crying outside the courthouse today. What happened? Why was she crying? Let me finish reading. She was crying out the courthouse today, begging for a press pass because she couldn't get a raffle ticket. She's not a credentialed journalist. I think that's kind of fucked up and unfortunate. And hopefully she got in. Hopefully she got in because the credentialed journalists they're reporting so dry on the situation. We're not really getting, remember, we can't see this shit on TV. So we need somebody that at least describes certain things that's going to take a little bit more opinion. When you hear I talk to lawyers for workers or even Byron, they're very straight edge. And you could tell like they're even scared of reporting that, yo, it's looking good for Tory, just because they don't want to get canceled, man. You know what I mean? Like, they don't get canceled. That's just what it is, and I understand that, you know. Anyway, this is, if you didn't hear what Wanna said, this is what he said.
Around 2016. Is that true as it pertains to you, Mr. Kitchens?
Yes, ma'am.
YSL is a music label and a gang, and you have personal knowledge that members or associates of YSL have committed crimes in furtherance of the gang.
Yes, ma'am.
You were present when law enforcement officers stopped a vehicle in which you were present along with Jeffrey Williams, wherein hydrocodone, methamphetamines, and a firearm were recovered. These items did not belong to you.
Yes, ma'am.
And do you acknowledge the following statement? I recognize, accept, and deeply regret
That's it.
that my talent
Dennis
and
Barton's
music
life?
indirectly.
Here's the thing. This whole case with Thug is fucked up. They're gonna be fighting 3,000 battles by the time. Like, yo, right now, Thug is just wasting money. And by the way, he probably got his lawyer on some crazy retainer. So like, it just is what it is. But he's just wasting money, like paying Brian Steele. And I'm not saying Brian Steele's amazing. Trust me, he's amazing. But bro, there's like 59 things that he has to kind of try to defeat for him to have a really good case once they go to trial. They got too many things against him. Now they're going to just throw Gunna on top of the witness list. Now they're going to throw that other guy that's the co-founder on the witness list. What you going to say about them? Like, yeah, you could, like, you going to take it to trial with those guys and say, oh, yeah, now Wanna just weak, or Wanna is only saying this because he want to get out of jail. Bro, you think a jury's about to just be like, yeah, right, okay, we believe you. You go free. So if you ask me, man, I think these are just kind of like placeholder. You know, obviously Brian still got to show that he's fighting. Like, yo, I'm still fighting for my client, not letting up. Let's see what's going on. But I think eventually they're gonna come to a number, and that number is what Young Thug is gonna agree to serve in prison, and that's gonna be that. And once that happens, it's probably gonna be kind of structured where everybody's gonna have to jump on the sword. And here's my thinking. They're probably going to be done giving out, you know what I mean? You got to realize, just think about it. You don't got to be no criminal to think about this. Like, if everybody get locked up, it's first come, first serve. You know what I mean? Yo, the first nigga to tell gets the sweetest deal. Let's keep it a bean. Like, if there's 28 niggas and everybody's like, nigga, I ain't telling no shit. The first nigga who said, all right, bro, give me like a Big Mac and give me some time off and I'll tell you some shit. All right, here's the best deal we can. The deals only get worse from here. You get what I mean? So I gotta imagine that going into the future, like if anybody else is gonna and you see, I don't litigate street politics. So when I'm talking, I don't want to call nobody no snitch. So I'm gonna say state's witness. That's what I'm gonna say. Because Vlad
prior to Judge Newkirk hearing the motions, prior to Judge Newkirk issuing the order that he issued, even if the court were to see it as more expansive than this,
what just happened
is, we had probable cause based on information and sources independent of the fact that the defendant had marijuana or firearms or whatever it was that was seen when the officers initially entered the home to execute what was and what is. It doesn't change it. The fact that the arrest warrant that was in existence at the time actually was valid and gave them lawful authority to enter the home does not.
Judge Newkirk ruled that you didn't have that at that point in time, because at the hearing that you had in front of him, or Mr. Bailey represented you all on the 3rd of April of 2017.
Tell everybody to refresh. I don't know what just happened. Sorry.
Particular certified copy of the arrest warrant, and so Mr. Steele by argument says, hey, look, I am extending my motion. I'm going to include everything that's in the house because you weren't validly in the correct space and place. Now, had you had that search warrant at that point in time, or not search warrant, but the arrest warrant valid at that point in time, then Judge Newkirk would have probably said, okay, well, then you're fine. But that wasn't that, these particular scenarios have to be ruled upon in terms of what the judge has at that point in time. So if you look at that, even if I accept, which I have, I've admitted, states 1, 2, and 3, you still have to return the man's property. He's asked for it to be returned. He hasn't had it returned pursuant to 17-5-30, because I can't go back and unring the bell in terms of Judge Newkirk's. You're not saying Judge Newkirk's ruling was erroneous, are you?
I'm saying that Judge Newkirk's finding was that we had not presented a certified copy of the arrest warrant, which is not the same as that there was an unlawful search and seizure. It's just that the state had not tendered.
On 3 April.
They said "La Bebe" and D Savage trying to hack my computer, bro.
So you're asking me at this point in time to say, hey, Judge, we can correct that. On December the 15th of 2022, you've introduced states 1, 2, and 3 certified copies of the arrest warrant, the return of search warrant and inventory, and the affidavit for search warrant. And that's why I'm telling you, assuming that is now corrected, the problem that you still would have is the return of property under 17-5-30, because you took the marijuana and the other pieces of evidence from Mr. Williams' home. I don't think the law distinguishes between that. So you would have had to return that. You still would have to return the property to him. So because at this point in time, he's entitled, or he would have been entitled, he's asked, and Mr. Steele has already introduced from in the last hearing on the 17th, he's asked me, or he's introduced a letter that he sent to Mr. Bailey saying, hey, I want the evidence back.
Your Honor, but the court did not rule that the state had to return that evidence, number one. There was no ruling as to that.
I disagree. I disagree with you. I disagree. By implication, Judge Newkirk had to have considered the fruit of the poisonous tree. Mr.
that the state had to return that evidence, number one. There was no ruling as to that.
I disagree. I disagree with you. I disagree. By implication, Judge Newkirk had to have considered the fruit of the poisonous tree. Mr. Steele asked him to do that. And it's a snapshot in time. So on the 3rd of April, 2017, you didn't have what you have now. And so you're asking me to correct something that is arguably, I mean, can I do that? I mean, and even if I can, that still runs afoul of 17-5-30. You still would have had to return Mr. Williams' property. And then Mr. Steele asked you for the return of that property. And there's no exception under 17-5-30 pretrial that gives you the ability to keep the property. You have to return the property. And then you took that particular property, in particular his phone, and then you extricated things out of it, which would be tainted or fruit of the poisonous tree, because you didn't have the right to keep that. You didn't have the right to keep that particular evidence under 17-5-30.
Thank you, Your Honor.
That's the ruling. That's the ruling, man. The judge trying to free Big Slime out the cage, man.
All right, let me finish what I was going to say. Okay, for purposes of Mr. Steele, you can prepare an order. Okay, sufficient to recap what the court has indicated during this particular motion. Now, I know that puts us in a position where some stuff that you may have the state was going to admit or utilize. Does that change your position, ladies and sir, about where you are with what would be admissible in this particular prosecution?
Your Honor, there are items that, of course, are affected by the courts suppressing the evidence that was seized back in 2015. There are some items that we believe may have more evidentiary value than others. And so it does affect.
That's my boy Uncle Phil right there, man. Salute to Uncle Phil.
Introduced in this case.
Well, I was just asking because if you need to sit and talk with Mr. Steele about what you can agree that would be not admissible at this point in time, given my ruling.
Why is this thing cutting out? This is not me. This is the feed directly from the court. Wow, this is cut. Let me see if I can go to live. Yeah, it's still cut out. Not too sure why that's happening. Let me see if Nancy Dillon.
Of the telephone company. The court went on to say that neither defendant, as one user of the telephone, nor the other defendant, as its lessee, had standing to object to the production of these records by the telephone company. Further, Your Honor, Regis, R-E-G-I-S-T-E.
One more time, R-E-G what?
I-S-T-E.
Okay.
Versus the state. And that is 292, Georgia 154. It's a 2012 case that is directly.
By the way, Mantis on YouTube, thank you for the 20 donation. He says, Merry Christmas, Zach. Appreciate you.
Telephone billing records are business records owned by the telephone company, not the defendant. As a result, defendants generally lack standing to challenge the release of such records under the Fourth Amendment because they do not have a reasonable expectation of privacy in records belonging to someone else. And that's a pen site of 249 Georgia 462 at 460.
So now they're going over phone records saying, yo, Young Thug's lawyers trying to get phone records tossed out, but they're saying no, those phone records came from came from T-Mobile, nigga, and unless T-Mobile is challenging it, we could keep it. And basically, even though you have a reasonable expectation of privacy in your home and on your phone for those calls, unless there's a search warrant or some wiretap, the phone records is actually not yours, so you can't argue that. That's what she's trying to say. Now, let's see what the judge says.
Expectation of privacy in the cell phone records of the Hertz Corporation. He has no.
Remember, they're saying that Young Thug rented the car from Hertz that was ultimately used to drive to the location to kill one named Nut. Okay, that individual apparently was very close with YFN Lucci. That started a whole beef between YFN and YSL. YFN is also, there's 16 members or 15 that actually are charged with the Racketeering Act, and there's 28, well now 27 because 26 because Gunna and the co-founder just slid out of that bitch.
Corporation wanted to contest the release of its own documents. The Hertz Corporation and only the Hertz Corporation, and all that they released, I will also make clear, it's not at all anything comparable to information contained in cell site location data that a person has within a cell phone that they keep on their person and that moves around with them. These documents.
By the way, somebody made a valid point. We do have some info on some paperwork for Gunna. Now, granted, paperwork don't mean you automatically snitch, but apparently this is the plea paperwork that is out there for Gunna. And it says Gunna has agreed to a certain couple of things. I mean, you heard him pretty much verbally agree to it when he accepted the plea and he later signed the plea. But here we go. Let me see if I can find it. Where is it? Paperwork would probably be, where's the paperwork? I might be scrolling down too far. Yes, I think I'm too far with it. Let's see if we can find it. Anything with Gunna, first pick, paperwork right here. Bingo. This is the paperwork, the pertinent things. So we see 1 year being commuted. His 6 or 7 months commuted to 1 year, time served. The remainder is suspended, which is 5 years. Okay. Next we see this is the special conditions. The parties agree that upon completion of the special conditions enumerated in 3B below, the suspended sentence will terminate by consent order. Okay, so they're saying that the only way you could get this consent, the only way you could get this get his sentence really terminated and also get the suspended sentence in place, he has to, if called by any party in this case, you will testify truthfully. Chat, I don't even know, like, we do love Gunna, but I don't even know what we're talking about here. Like, nigga, if it's in your plea agreement, if called by any party in this case, you will testify truthfully. No, come on now. Like, I think, some people are politicking it. I think all y'all want to hear is, yo, he ain't get up on the stand yet. Well, nigga, he ain't get a chance to. The trial ain't start. This is pre-trial shit we're hearing. This is all pre-trial shit. So he ain't get it. I will bet with anybody, if anybody takes this shit to trial, which, by the way, ironically, all of them, or YSL had a song called Take It to Trial. I guarantee none of them going to take it to trial. But if anybody takes it to trial, Gunna's on the stand. Facts. And Gunna's on the stand, and he has to point niggas out. That's what it is. He has to. It's in black and white, or actually red right here, nigga. He says, if you're called by any party, there's 26 other people that haven't resolved their case. If 26 other people don't plead out and any of them take it to trial, he, by signing this document, has to take the stand. I don't care what y'all say, he got to take the stand. It's right here. I know how to read English. If called by any party in this case, you will testify truthfully. But you reserve the right to assert your Fifth Amendment privilege, which, by the way, that's about self-incrimination, not incriminating another motherfucker. So, hey, if anything that you haven't told us, so he doesn't have no immunity deal. If you haven't told us about anything, or we didn't find out about anything, we only charge you with this one thing. If you get up on there and somebody asks you a question like, yo, like say the prosecutor said, did you used to smoke crack with him and sell crack with him? He's not charged for selling crack. He could evoke his Fifth Amendment because that would incriminate himself for selling crack. But if the question is, yo, say he never sold crack and he knows that guy sold crack. Hey, did that guy ever sell crack? Gunner has to say, yes, he used to fucking sell crack. That's what happens, bro. Bro, it's right here. Agree to perform 500 hours of community service, complete at least 350, a substantial portion which will require you speak to young men and young women about the hazards. Yep, this is a TI-like plea. I'm gonna be honest with you. I'm not calling nobody no snitch because I'm not in that realm to even care about people who are snitching. I'm just telling you what this fucking document is saying. This is basically, yo, TI, go record a commercial. Except they're not telling Gunner to record a Crime Stoppers commercial. They're saying, go talk to all the kids and tell them, don't do what you did. Don't join gangs. Sorry. He says you're going to be talking to them about the morality of gangs and gang violence and the decay that it causes the community. You agree that community service locations and it shall be determined by the Office of Fulton County District Attorney. Okay. There's this other part. It says that he's also a first offender. It says he can't have any guns. He can't have any guns during the term of the sentence or any time thereafter unless your right to do so is restored, and you cannot commit any criminal acts. And here it is. It seems like he's a first offender. And hey, you could say, well, he probably won't have to tell whatever. But I think the only reason why he was even eligible for this is because he didn't have that many. I don't think he had no charges like that. It says this is a first offender conditional discharge. First offender conditional discharge. Yeah, there it goes. And the defendant had to sign here. If you're firearms, you're convicted of blah, 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 whatever. Okay. For him to get out, he had to sign here. And it says Sergio Kitchens. Now, y'all can make your mind up on that. I don't want to tell y'all what to think. Anyway, let's get back to this.
About the state's method of obtaining the records from hers. So I would ask that.
Let me deal as a preliminary matter, threshold matter. If that's the case, the records, your client would not have standing. I would grant the state's motion as to the curse records.
Understood.
Okay, so is there any other basis that for asking for at this point in time?
So they're saying that the records that Young Thug rented the car that was used in a murder, they're still keeping.
Mr. Sprinkle, if you allow me to briefly proffer.
Okay, you're going to proffer as to why you need to call Mr. Sprinkle.
Yes, because I think that's where it starts. So what happens, Your Honor, is Mr. Williams is wrongly targeted by law enforcement for 10 years, since he's 21 years of age. And during those 10-year period, there's a systematic abuse of process by the people who claim that other people break the rules, and that's the District Attorney's Office of Fulton County. And what I'd like to call Mr. Sprinkle and prove to this honorable court is as follows. First is what you just heard from. Law enforcement officers and the District Attorney's Office is aware that the Honorable Judge Newkirk found that law enforcement had no right to go into Mr. Williams' home in July 15, 2015, take devices. The prosecution does not restore those devices. You already ruled, I know Judge Newkirk ruled, but that's part of the issues. What right does the prosecution, the District Attorney's Office, have to keep that property and then to send it to Cellbrite without a warrant and have it searched? I want the court to consider that. Then I want the court to consider the following. The fact that the District Attorney's Office did not go back to a judge and say, we have this property, we're supposed to give it back. We are doing another investigation, we want another search warrant. They just go and Cellbrite, I would introduce through Mr. Sprinkle, says, as a courtesy of the district attorney's office, we're going to look at this device. I would like the court to have that in its breast when deciding whether there's extreme prosecutorial misconduct. Then what happens is grand jury subpoenas. I'm not moving to suppress anything at this point. I'm not waiving any argument, but I'm not moving to suppress. But this is how the grand jury subpoenas were given out in this case. And it's not only hers, it is every grand jury subpoena. I've attached them to the motion. And what the grand jury subpoena shows is that from his office, presumably, Mr. Sprinkle is on every one of these. He has a district attorney seal.
Yo, chat, real quick, not breaking news. This is exactly why I had to sit that thing on. I can't read it verbatim. Why my mama gonna text me and said, she says, hey, she said, why your auntie called me and told me you're on TMZ and says you're defending yourself against, let me just leave it alone. You know what I mean? I told you I can't make headlines with certain people, bro. Like my family looking at me crazy. Like, they don't care about no other headline. Wait, what the heck? You know what I mean? It's like my family's like, wait, what's going on here? You and some dude named Saucy Santana? Wait, hold on, what's going on? Yo, they don't care about nothing else. We from Jamaica. They're like, yo, why is you and that person's name even like I'm like, you see why I had to mama set me straight. Yo, my mom probably wish I get my ass whipped by a little baby more than me going back and forth with a nigga with a beard and a BBL named Saucy. Listen, for real, I can't disgrace my Jamaican heritage. I gotta chill. All right, back to the NC Dillon chat. Hold on.
And the court's inquiry review is what reasonable expectation of privacy do you have or standing do you have in these records?
This is not the issue. This issue goes to dismissal of an indictment for prosecutorial misconduct. Mr. Williams was indicted. I'm not trying to suppress the evidence based upon your ruling and the case law. What happens now is there was such egregious misconduct by the district attorney's office.
So you're saying you'd like to examine Mr. Sprinkle for his motives or for as to why he sought these particular documents in this prosecution.
I want to subpoena, well, I have subpoena. I want to call Deputy District Attorney Mr. Sprinkle because I want to ask him why he believes he had any right, which I'm contending violates Mr. Williams' rights to due process as stated in State versus Lampel, LAMPL, 296 Georgia, 829. It's in Division 2, 2015 case. It's in my motion entitled Mr. Williams' motion to dismiss indictment and or motion to suppress evidence filed on 11/3/2022. And what the Supreme Court of Georgia held was it is an extreme remedy to dismiss an indictment or a count thereof.
Real quick, I see someone in the chat asking one of my subsies, RT No Class, update me on what happened with the cell phone. The cell phone's out of here. They're now arguing about a very important piece of evidence. They're trying to connect Young Thug as some kingpin who took out a car from Hertz, gave it to the basically foot runners and say, yo, you niggas go do a murder, okay? That's what the prosecutor believed. That's why they believe that car was connected to the murder of Nut, because allegedly that was a car used. They're trying to suppress that, but it doesn't look like the judge going for this. They did go for the cell phone. The cell phone's out of here, where he was talking all this, yo, we young slime niggas gotta die for the cause or sacrifice, all that shit.
It has nothing to do with this motion. This motion is not a motion to suppress. It is a motion based upon a violation of due process rights because everyone here, I assume, joined the motion. Everyone here is suffering from the state of Georgia's unlawful.
Right now, they're trying to do a pretty much a motion or argument to dismiss the whole case. saying that the prosecutors have just taken too much cuts in the corners that this should even be a case, and they've violated everybody's rights. They should throw this whole thing out. I think this is going to get shot down.
296, Georgia, 892, Division 2, 770 Southeast 2D, 629, 2015. I had the honor of representing Mr. Lample. On that case, it went to Court of Appeals of Georgia, then the state sought certiorari, and that's how the Supreme Court got that case. He's the mayor of Amara. Mr. Lample's the mayor of Amara.
Okay.
And that's why I would like to call Mr. Sprinkle, because he's sending out, under the auspices of a grand jury subpoena, with the district attorney seal, without the clerk seal, outside our state. They've taken evidence from Mr. Williams' home, not returning it, searching it, regardless of Judge Newkirk's finding. And then, Your Honor, what I'd like you to consider, and Mr. Sprinkle would be asked, there's a recording in a grand jury, and it happens on June 15, 2018. Mr. Sprinkle and law enforcement officers who were present in this courtroom subpoenaed a woman named Ms. Morton, M-O-R-T-O-N. They brought her before the grand jury in Fulton County. They didn't like that she wasn't talking with them. They put her under oath. And they said, it's Mr. Sprinkle is said on recording right at the beginning. It's at 10 seconds of the recording. He says, because in Georgia, it's not an investigative grand jury unless the court deems a special purpose grand jury. It's not federal court where you could do an investigation. The state of Georgia, you need a proposed bill of indictment already against the person and what the charges are. State of Georgia versus Brian Steele, here are the charges. What Mr. Sprinkle tells the grand jury is, this is not an indictment under consideration. We are just here to hear Ms. Morton testify. That's not valid. So I'd like to ask Mr. Sprinkle what right he had to use the grand jury as a district attorney's investigative tool. Those are my five issues. The search warrant, the search of the devices, which already ruled. Why did that happen? Why did the subpoenas come without a clerk? Third one is, why would the subpoenas go outside of the state of Georgia? The fourth one is, why wouldn't you return the property? And the fifth one is, why would you bring a human being before a grand jury when you don't have a real bill of indictment, and you tell the grand jury that this is not a bill of indictment under consideration? What right does the district attorney have? And that's why I subpoenaed the young man.
Okay.
Your Honor, the defendant still has not addressed the issue of standing as to any of these.
He's indicted.
No, Your Honor. The conduct that he is complaining of, he has to have been aggrieved. He has to have an expectation as it relates to that conduct.
I think that's what he's asking me to test. I think that's what he's asking me to test. And he's also saying, hey, he's an aggrieved person because he's under indictment for these bigger charges. So,
and Your Honor, if I may, I don't know why Mr. Steele cited Lample in his brief, because it actually supports the state's position in this case. In Lample, a special purpose grand jury investigated the defendant and subpoenaed that defendant. In this case, it isn't even that the defendant was subpoenaed to testify. He is talking about a person who didn't even yield information that was used against him. He is asserting that actions that he has no right to complain of should be somehow used as a basis for dismissing a lawful indictment against this defendant. So he is, I guess, attempting to leverage the court's ruling previously into something that simply doesn't exist. He does not have a right to complain of the actions he asserts were unlawful or improper. He simply doesn't. And he hasn't addressed his being indicted alone does not give him standing. to argue or to complain about the fact that Ms. Morton was taken before a grand jury, or that a subpoena was sent to a corporation or a company or an entity that the defendant has no expectation of privacy in. He simply doesn't get past that initial threshold. And by continuing to fold one argument into the other, he attempts to subvert what the courts
Why does she keep having a chat? Anyway, we here, man. Let me know if we're getting any other updates. They're trying. I don't think this is, they're trying to get the whole case dismissed. Man, the prosecutors need to stop playing. Obviously, they got to fight every little thing, but they need to just drop the bomb. We got mad snitches on
Supreme Court, they've been indicted, and when the Georgia Supreme Court says, nope, you last standing, it being indicted doesn't afford them standing to argue about matters that they have no right to complain about. And so he has bundled up a whole bunch of matters as they relate to other entities. Frankly, with respect to Hertz or any other entity, they can simply give us the documents we requested them.
Hold on, we got some updates from Megan Cunniff. She said thread broke, but here comes info about the detective coming testimony. Yeah, pretty much. Okay, I think we read that already. We're in the hallway, prepared to get in. There's another line. People blah, blah, blah. Reporters noticed that this morning that no one from the public was allowed inside the courtroom during the outside of jury discussion about the detective and other evidence issues. Wow. So no one from the public was allowed inside the courtroom. One issue the judge is considering is whether the prosecutor should allow them to play the entire 80-minute. Oh my God, they're desperate. They're desperate. They're trying to play the keep in mind, this happened 2 years ago. They just interviewed Kelsey in September, and because Kelsey didn't say what they want to say, they're like, we got to play her whole recording. Obviously they recorded it. We want to play the 80-minute recording from her in September based on questions Tory Lane's lawyer asked in her cross that the DA said unfairly questions the DA approach. So basically they want to say, we're down to play the shit to show y'all that there hasn't been prosecutorial misconduct in fucking trying to get her to testify. Like, we really thought that she was telling the truth at first. She's the one switching up. We ain't pressure her at all. You know what I mean? So obviously they're going to play it to see if they're trying to coax her or trying to pressure her, you have to testify, or if you don't testify and Tory says you did it and we don't get him, we're going to get you. That's interesting. All right, cool. Let me see what else. Yeah, I think that's the latest. Okay. All right. Back to this Young Thug shit. Let's see what's going on. All right. Look like they're either taking a break or something. I think the judge has left the. I don't think I see the judge at the seat here. Maybe he is. You guys could. Actually, I think he still is. He's looking at the computer. You can tell me if he starts speaking again. Again, I think this case has just gotten incredibly still difficult. They scored a major win today, so salute to Thug. I think Thug's lawyers is doing the best they can. I don't believe they're going to go to a trial eventually. I think they're going to try to fight this for as long as they can to somehow weaken the case as much as they can to get a favorable plea from the prosecution. But I don't see them going to trial. And the reason I don't see them going to trial, and by the way, I think they're playing a time game. I think the more and more time goes on, the more and more defendants the prosecution is going to flip as witnesses, whether it's going to be overtly niggas who are saying, yo, that nigga did it, or a nigga be like, yo, well, I'm down to tell you the truth about some shit. They're going to be jacking up that witness list. And I think they've clearly identified that Thug is the main person they kind of want in that. They will not be happy if Thug gets anything below 10. And right now, based on how his lawyers are going about it, the longer this takes, the more they're probably going to be unwilling to give him, oh, yeah, time served and do the rest out of jail. I think they'll probably push towards, no, nigga, we need some significant time. And just off the fact that this is a public issue now, like they don't want to look like they've been unfair or biased or they don't know what they're doing or they're stupid. So now they're kind of dug in. Thug's lawyers are dug in. And we're going to see if this goes to trial. You know, YSL had a song called Take It to Trial. I feel like I bet 100,000 this shit don't go to trial. Why the hell would you go to trial with this shit? They got all type of data. They got cell phone records. By the time they're done painting the picture, they're definitely going to get you guilty of at least being in a gang, right? They're going to be like, yo, he's at least guilty of the gang. And if they really get you good, they're going to be like, you've called all the murders, right? And now if they got you as the head honcho who called and ordered all the murders, even if, and I think some of them guys is going to go down on murder, right? Even if you don't motherfucking, even if you don't get charged directly or you're not on those bills or that those particular charges for murder, I think they're going to sentence you to some significant time. Significant. And again, I think at this point 10 years is light. What I think about Young Thug's sister saying it, I can't say she's saying it to say, oh, he ain't snitching, we cool with him. I think she's saying, yo, listen, right now, Thug knows he can't say nothing to Gunna. He can't put out no message in the air to say Gunna's a snitch. He can't do nothing. And to be honest, he also would rather, you know, Gunna's still in the gray area where maybe Gunna says, you know what, fuck it, like I still have a rap career if I don't ever take the stand. So who knows? Let's get to trial, and Gunna says, I ain't taking a stand. I ain't taking a stand versus my brother. You get what I mean? So they're not just trying to blow it up now by just making, yo, he is snitch. You know what I mean? It's right now Gunna took a plea, but pretty much it's only intent, like at least on the prosecution side, it's only intent to testify. He ain't testified yet. With 6ix9ine, they saw that nigga up there. Or actually, most of them just plead out. As soon as they see that, they plead out. The only difference is niggas like Shotty just didn't have any chance. And also niggas like Shotty didn't have like a big bankroll like Thug. Thug is ironically the top of the ladder and the richest nigga who's on the trial. So everything falls on his shoulder. React to Charleston White talking about Gunna. That would be great. Okay, this went out again. What Charleston White say? You know Charleston White gonna say some good shit. Charleston White, Gunna.
I'm doing something great. I've been doing since been pimping. and setting the record straight. I'm gonna make it cool, boy. We got Gunna, one of the biggest rappers, goddamn it, on earth. Done agreed to cooperate and stood before the court and said, Your Honor, I want to make this clear. Y'all a gang, right? Yes, ma'am. And you did wrong, right? Yes, ma'am. What anybody else can say that's in the gang? We not no gang. We're a rap group. We're a rap label now. The boys before you that was in this rap label that you trying to say y'all a gang. And people died in the name of this gang. That's your ass, Mr. Rap Man. I want to see, and one thing I want to say, y'all named Lil Boosie, we need you to speak on T.I. Lil Boosie, we need you to speak on Toe Tapping Tippy.
What?
Toe Tapping Tippy.
Nah, stop.
We want to hear what you got to say, Boosie. Big Facts podcast. We want to hear what y'all got to say. 85 South, DC Young Fly. We want to hear what y'all got to say about your boy Toe Tapping Tip. Now, the boy done got away. Y'all forgot the nigga got caught with all them X pills, him and his bra, remember? Remember him and his bitch got caught with the motherfucking X pills while he was on the federal probation after the guns. Y'all don't remember that, do y'all? How did that go away? Toe Tapping Tippy. And from what I hear, them girls is still on his ass by them putting his foot in their pussy. Now, damn woman in the world won't no motherfucking foot in the pussy. Now I heard some fisting going on, but that's some old sick cave sadistic white boy shit. Putting your foot on the pussy, that don't make nobody come. Nobody gets to come with the feet tapping on the pussy. That ain't pleasurable at all. And she might get a gangrene, a fungus infection, because feet is nasty. Yeah, motherfucker get gangrene on that pussy from them feet. Nigga done something wrong in the motherfucker. Some niggas say it's all right to put your mouth, but all I know is dick and pussy go together, nothing else. Dick and pussy go together, nothing else. All right? That's the lesson for today. Dick and pussy go together and nothing else.
Mr. Bailey's, not Mr. Bailey, but Mr. Sprinkle. You're challenging
tell T.I. take the
by
fight.
way of
Yeah,
the
fuck
evidence
all
that
that.
you
Tell
were
that nigga take the fight.
presenting, or that.
Hold on.
Yeah, man. Shout out, man. Say, I got some niggas send me a prayer, $400 prayer, motherfucking me. The whole goddamn shit. Say it was an old nigga in front of the road looking up there. It had 3 women with video right here, and I be looking at the motherfucking video like this. Nigga pulls the trigger and kills somebody in the process of them stealing starter jackets. I thought we were YSL. I thought we would shoot them up, bang, bang, kill them niggas, shoot them niggas, come back and spin the block again and shoot an innocent victim, come back and spin the block again and shoot his little sister, come back and spin the block again. Now we shoot him finally. So now we done all this. All us is in this together. Remember, we gang, y'all. What happened to a plea bargain is I'm agreeing to tell on us, because by me telling on me, I'm telling on us, y'all. Free Thugger, I hope they give him at least 10 years. I want to see, do he really like wearing dresses? Yeah, I want to see if Young Thug really like wearing dresses, because out here he was painting his motherfucking fingernail. He was wearing dresses. He was giving us mixed signals as if he was gay, and he didn't know he was gay. Let's see if he gay. Now we can finally see if Young Thug gay. See, a jailhouse don't bring out the gayness.
I'm gonna be honest though. I don't think Young Thug got broken by jail, ironically. So I really got to believe that whatever Thug was talking about, I'm not saying he was living it, but he understood the consequences of it. You get what I'm saying? Now, Gunna, I think Gunna, I don't even know how Gunna found a new chick in jail. That shit's crazy to me. You could tell Gunna could have waited to come out. Gunna found a new chick in jail. This thing ain't want to come out single to find a new chick. He found one in jail. That's crazy. Nigga, that's crazy as hell. Gunna was already lining some shit up in jail because he wasn't. He probably was telling her, man, them folks told me I'm about to do 10 years. Nigga, I'm about to be out here in 2 weeks. I don't know what they talking about. Shorty, send me another picture of that BBL. Remember, you can't show the pussy because you got to come through the mail and, the wardens be hating and shit like that. But I'll be out here in 2 weeks. Fuck that. Fuck that. Matter of fact, yo, where you want to go for New Year's Eve? Fuck that.
I should go to that penitentiary. That penitentiary, they got some ways to bring out that shit out them boys down there. Say, no, we need that boy to go down there and see if he really thugger. See if he hugger. See, yeah, we need to see if that boy go be down there and stand on them rap lyrics. Or they go get him down there and see if they can paint his fingernails and get him to wear some of them dresses that they like wearing when they put the sheet over the window. Yeah. So we don't want to hear nothing about freeing no motherfucking thug. We already see the rest of them ain't tough. We see Gunner and the rest of these boys ain't tough. They ain't even been gone a year. They already done broke weak and took the plea agreement. They were supposed to do like them goddamn white boy bikers out of Waco. Y'all hear me? They were supposed to do like them white boy bikers out of Waco.
That is true, man. When it comes to solidarity, man. When it comes to solidarity, clearly, like, yo, them dudes out of Waco, they stood together. Niggas, man, you know what it is, bro? Let's keep it real about, like, telling and all that shit. Bro, people got too many things going on for them, bro. People got families. People are walking companies. Gunner's a walking company. He got his mama, he got like all his relatives relying on him. He got situations going on, bro. Like, all that real nigga shit, stop, bro.
Had a shootout with the police at that motherfucking Twin Peaks restaurant. Not one white boy said a word. They didn't take a plea or nothing. People died, police got shot, police killed people and everything. This made national news. Not one white boy biker said a word. They didn't take a plea agreement. So I'm starting to think that white boy motorcycle bikers is way tougher than gangster rappers. Yeah. I want to see somebody go fuck. Say, listen, if anybody can bring that hoe up out of you, the prison conditions can bring it up out of you. So I recommend every nigga think he tough. I recommend a stay in prison. Yeah, I recommend a stay in prison for your motherfucking ass. Nigga, you think you tough? Okay, we got somewhere for you now. If you come out of here tough, boy, you tough. Yeah, if you can come out of here tough, Junior, boy, you tough. You can rap however you want to rap. You can come whoop whoever you want to whoop. Yeah, man, I'm telling you. Yeah, I know some niggas been whooping ass ever since they come out of prison. They whoop their ass in prison. They whoop ass out of prison. Now, they don't just whoop everybody. They give ass whoopings to words worthy and warranted. I'm so happy. This is a great day in the black community. Gunner is out of prison. I never thought I would be happy to say y'all, Gunner is out of prison. Now, I'm glad he got out by telling. I think that was smart, Gunner. I'm a Gunner fan now. I'm a goddamn Gunner fan now, boy. That's all y'all finna hear in my motherfucking CD is Gunner. I'm gonna tell. That day, Gunner. I'm gonna tell, nigga. What? I'm the new Gunner. Yeah, that's the one. Gunner. I'm gonna tell, nigga.
Nah, I ain't gonna lie. Charleston White too funny, man. Charleston White is one of the funniest niggas in the game, bro. I ain't gonna lie to you. Hold on, let me get back to this shit.
That I said you didn't have any standing to see what Mr. Sprinkle, in fact, did present to that grand jury and what he told them. So
I actually won't do that. What I'd like to do is, why did Mr. Sprinkle serve grand jury subpoenas? Why did he do the process the way he did? I'm not going to ask anything about what happened in grand jury, except I have that recording that was given to us in discovery.
Was it discovery?
Yes.
Okay.
Will not ask anything about what occurred in a grand jury, except what was given to Mr. Williams in discovery by the state of Georgia. It's a recording.
Wes, do we have a copy of the motion to suppress? Yeah, that's what the motion was.
Go now, people. Young Thug fight for his life. And Curly Gunner is taking like 1,500 whippets right now, man. Who y'all rather be? Young Thug in court or Warner, who is right now nestling his head in the ass crack of an IG model with her oversized body? I ain't gonna lie. It's at the point Young Thug might have to find a nigga to tell him. He might have to find some other devious shit to tell him. Be like, yo, I thought I was bad. I know something worse. Let me out. Come on. Yo, you know that's the game, right? Be like, oh, where'd y'all want me? I know a nigga who do some shit worse than me. Get him and let me go. I found Gunner's ting too. Y'all want me to bring up Gunner's ting? How Gunner bag this in jail? Y'all niggas is free walking around, going to the gym. Y'all outside every day. Y'all can't even get bitches like this. Gunner was locked down on 23-1. He get an hour to shower, an hour to shave. He get an hour to shower, shave, workout, and call his family, and he still bagged a bad bitch. What excuse you got? Gunner bagged a bad one while he was locked down for 23 fucking hours. What fucking excuse you got that you fucking with 2s and 3s or beating your dick every day with no pussy? Let me see if I can find her.
Okay. I will on the issue of the. All right, I think I'm back on at this point in time. In terms of the motion to quash the business records, I'm also going to grant the motion to quash the subpoenas, both subpoenas 1 and 2. The court is of the opinion that of the relevancy of the newspaper records, but also they're protected by work product under 24-5-501. And for those reasons, I'm going to deny, I'm going to grant the state's motion to quash on those two subpoenas. All right, anything else?
Thank you, Your Honor.
All right. I have some proffers I need to deal with.
Hold on, Chad. I'm gonna find it.
Mr.
Chad, if y'all got an ad name, send it to me. But I saw it earlier.
Mr. Hoover?
I'm sorry, Your Honor, before we do that, I just want to bring the court's attention. Mr. Kendrick has voted to suppress.
Oh, yeah, we got her.
On the record, we have a witness here, I've spoken to counsel, he doesn't intend to go forward on that motion. If you're
He does not intend?
we were hoping we could release our witness who's in here, so.
Yes, any objection, counsels?
No, just to be clear, we're not withdrawing the motion. We would just like to argue that on another time.
And your name again, I'm sorry.
Doug Weinstein.
So right here.
T-I-N-S-T-C-I-N.
Mr. Weinstein, what is your client, what's your client's name again?
My boy Gunner.
Kendrick.
Holy. Fresh BBL.
Your Honor, we're just hoping our witness might be able to go.
Well, you know, folks, I like to be able to accommodate everybody, but you saw what happened this morning, okay? We had a technology glitch that nobody could have foreseen, I should say, and we're kind of a little bit behind. So we're a little bit behind in terms of just being able to properly conduct court.
Yo, chat, Gunna bagged her in jail, nigga. What's your fucking excuse? Gunna bagged her in jail, nigga. He only had 20 minutes to like surf the Wild Wild Web, nigga, or what's called World Wide Web, nigga.
Turn yet?
Oh,
You
son!
jumping in front of Mr. Steele now?
No, I am not jumping in front of
Okay, all right. What is it you'd like to tell him?
Well, I filed the exact same motion that Mr. Steele filed
And
regarding
your client is, sir,
Stillwell.
Mr. Stillwell?
And that
Okay.
was filed on November 16th. And
The motion to dismiss the indictment
motion to dismiss the indictment.
and motion to suppress evidence. You wish to table yours at this point in time?
I have not heard you rule on the actual motion, just on the subpoenas. And I would just point out to Your Honor that our argument is not based on any Fourth Amendment violation that would require standing, but rather prosecutorial misconduct, which I believe as citizens of the United States, we all have standing to challenge. And Mr. Stillwell, who has been indicted and investigated in part by legally issued subpoenas.
I'm going to deny the motion to dismiss the indictment. Okay?
Okay, well, I just wanted to make sure it was on the record that I too have filed that motion and.
All right, I'm with you. Okay, all right. So to the extent that's been ruled upon, that's fine. Anything else?
Thank you, Judge. Just want to hear for the record.
Yes, Mr. Menezes.
I have failed to adopt the motion in writing, but I did want to respect the record that that's on me, and that was effective. But I do want to orally also adopt Mr. Steele and Mr. Sharp's motion.
All right. Well, you probably should reduce that to writing, but Ms. Rosenwasser, if you will include that in order, please, madam.
Yes, Your Honor.
Yeah, I'm going to, in the motion to suppress and motion to quash, okay?
And Your Honor,
You can-
would you allow me to incorporate Mr. Steele's argument into the record on behalf of Mr. Steele as well, so I do not need to cite to the same cases and.
Yes,
Thank you.
so we'll include you as well. Okay, anybody else? All right. Okay, before
By the way, it's during the time when there should be another break in the Tory and Meg case, so please let me know. I'll switch over.
Yes, Your Honor.
okay, do you have the issue of the proffer that you'd like to complete at this point in time? Do I have any, I was going to ask you to complete that issue of the proffer. And then also, if there's anybody else who we still need to deal with the issue of the proffer.
I'm not sure which proffer.
Ms. Rosenwasser, you want to address that, please?
Your Honor, I believe the court is referring to your continued, Mr. Hoover's continued representation of Mr. Someone after you were disqualified as to Mr. Blaylock, to see if Mr. Blaylock was on.
I don't have too much. Just we could go back to the live version of this. Yeah, this is really horrible. Like reception that's coming from this feed. If you want to recap on everything that I've gone over so far today, right? And we've been streaming for 3 hours. Number one, Young Thug's lawyer successfully knocked out the cell records that showed him communicating and ordering things that would be in congruence with being a gang leader. So he was saying, yo, niggas got to do this or niggas got to get out the way. He was talking with other gang leaders that established Young Thug to be a leader of a gang. That will not be admissible in court. That will not be allowed to be used by the prosecutors. Okay, so they're going to have to use a lot of probably witnesses that they have now turned, including Gunna. And I'm sorry to say it, Gunna is a possible prosecution witness who would probably be called to testify to the hierarchy of YSL, whether in a component of being a gang or a music label. Just say, hey, listen, if Thug said something to somebody else who was YSL, would that person listen? Would they do it? Would blah, blah, blah. Do people have to listen, have to come to Thug for permission? In the indictment, it said that when niggas wanted to do something to YFN Lucci, they had to go out of their way to try to get the permission of Young Thug. That all goes to the narrative that Young Thug is a leader and probably a top, if not the highest member of YSL. They've at least got the cell phone stuff out the way. Now, they claim not only that Young Thug is a top guy in the gang, they believe that Young Thug has ordered or probably was behind the death of one named Nut, which sparked the beef with YFN Lucci and the YFN family or the YFN gang, whatever they call it. Now, Young Thug's lawyer said, no, you shouldn't be able to use the info that Thug ordered the car. The judge did not agree with Thug's lawyers, and they, on that particular situation, said the prosecutors are right. You don't have any right to the records of what Hertz has, and Hertz isn't going to come in court. You know, there's few companies that historically have gone to bat for their customers to say, hey, we don't want to share our info with you. And it's not really that they cared about the particular customer. They cared about the principal. Hertz don't give a fuck. You rented their car, you did a drive-by in it, or you did a shootout in it. They're going to tell on you, or they have not tell on you, but they have no problem with giving the records up. The judge said that is going to count. Now, you had Young Thug's lawyer who said, well, there's a lot of like, gray area and a lot of lines crossed by the prosecutor. We should probably throw out the whole case because really this seems like a lot of prosecutorial misconduct. The judge disagreed with that. They're trying to knock down some other stuff, and currently the judge is looking at it now. Essentially, it's a win for a loss. And by the way, if you ask me, this is my personal opinion, but I do believe that the judge, well, not the judge, the prosecutor probably thought about giving Gunna that plea because they knew this would happen. This was being put into the air from time, saying that there was illegally obtained information that was in this case, that without this information, the case would be significantly weaker. That is true. However, the prosecutor, I think, has made up for it because they have given a bunch of pleas to the other guys who will now tell on Young Thug anyway. So they're like, all right, fine, we don't got your cell phone, but we got a bunch of dudes you were texting. By the way, the co-founder, who they just also gave a plea, is one of the niggas he was texting. So whether they have the phone or not, if Young Thug takes it to trial, they're gonna be like, okay, we can't use the phone info, but let me ask him. We could bring him up on stand and said, hey, has Young Thug ever hit you up and said, hey, listen, for the niggas got to get sacrificed for the betterment of what we got going on? And that person is going to be obliged to say yes based on the plea he got to say yes. Young Thug did talk about niggas got to get sacrificed for YSL the gang. You know what that then proves? Young Thug is one of the leaders of YSL the gang. Then they're going to bring up Gunna. Hey, Gunna. Hey, what's your deal with this? What do you know about this? You know what they're going to pinpoint with Thug? Hey, listen, in that situation where we got pulled over when there was a bunch of shooters in the back with other cars, but even specifically the car, did Young Thug have a bunch of drugs and gun in that car? You stated already in your plea, it ain't yours. Is it reasonable to assume it was Young Thug's? Remember, maybe he could invoke the fifth and you could think of some Kelsey shit, but at this point, it looks like he probably got to say, yo, I know Thug, that gun was Thug, or those drugs was Thugs. You know what I mean? It is what it is, bro. Like, again, I know y'all want to, like, we all over here, like, nah, we love this shit. I love all these guys' music, but it is what it is, okay? So I caught you up. Hopefully we'll get like a final ruling on everything. I'm waiting for this. It's not the best feed in the world. We're also waiting on the Kelsey trial. The judge is reviewing a bunch of stuff, is reviewing, let me see. It looks like he's about to speak again. Let's see.
Okay, Ms. Harvey, did I answer your inquiry? Yes, thank you, Judge. I'm just here to get my COEs from this response.
That's not true. He's old enough to where he don't need COEs.
That's true. That's true. So is David. You hit 105, you don't need that.
Well, I heard you saying that on 70, you're good, so, yeah. Was that easy? All right, okay. I'll track that. Okay, is anybody else? That you otherwise not told me you'd like to go ahead and entertain the motion? Ms.
Well, Your
Black?
Honor, I have a different issue. I was just retained and just filed my entry, so I do not believe that I have any motions pending, but I'm not sure if there were any that were unheard by previous counsel.
Okay, what are you representing on the table?
Trontavious Stevens, Your Honor. Mr. Flugel had to withdraw because his wife had a medical issue.
Yes, that's true, and we are familiar with that issue.
Yes, sir.
I would like, he has several motions, ladies and sir, if we ever rule on any motions that I know we argue, some.
Your Honor, some of the motions were ruled on, I think the Sullivan demurs that Mr. Floyd handled last time.
Yeah, Ms. Black, I've got a couple, but he's got motion.
I'm sorry, Judge, maybe not hearing it.
One more time, one more time. On the record.
Thank you, Judge.
There is a motion to limit the testimony to facts stipulated in the plea colloquy. I don't believe we've taken that up or taken that issue. I know that we ruled upon the special demurs as to counts. Count one, acts 48, 49, 50, 52, 53, and 54. And the special demurs to count one, acts 127 and 132. Mr. Floyd, did we take up anything else in regards to as it relates to Mr. Stevens? I believe that you argued and I ruled upon those particular motions the last time they were here, sir. Is that correct?
The ones that you just described, Judge, yes, you did.
The lady in the pink keeps typing because she's probably the stenographer. So she's the person responsible for the transcript. They probably have an audio device that's also like, doing it technologically, but also she's going to do her own. And then they kind of like join them into it. Then they'll redact it before the public because all these are going to be public. Criminal hearings are going to be public. Sorry. What the fuck? Is this shit just muting randomly? I didn't turn it off. These are bailiffs. This is a stenographer. This is the judge. There's other bailiffs around here. There's a lot of defendants in the court, so there's probably more than enough bailiffs, you know what I mean, in case niggas start getting rambunctious. Don't know. Like right now,